wait. Okay, come on. We're going to get there. Maybe we might get there on Tuesday now. Subjective intent of the officer, what we were talking about before. Let's think about the Supreme Court repeatedly telling us, you don't look at an officer's subjective intent. Remember in Arkansas versus Sullivan, what they say is a traffic violation, it cannot render invalid the fact that it was a mere pretext. These can be narcotics detectives in an unmarked car. They haven't stopped anybody for a traffic offense in their entire career since, in 40 years. But this guy didn't have his seatbelt on, so they go bust the guy. And they say it doesn't matter, as long as objectively you have a right to do it, it doesn't matter what your subjective intent was. Interesting in Brigham City case, you might want to take a look at this in the materials. This is a Supreme Court case from 2 years ago, and in this case the officers enter, they see through a screen door there's a fight, and there's a guy it looks like he's bleeding to death. And they bust in under the safety exception to render aid. They blow him off, leave him, he's fucking bleeding. And bust all the guys in the fight and find some drugs. And the Supreme Court said, it therefore does not matter here whether the officers enter the kitchen to arrest the respondents and gather evidence against them or to assist the injured and prevent further violence. So they can just ignore some poor bleeding guy, and that doesn't matter because you don't look to their subjective intent. By a unanimous opinion by Chief Justice Roberts. We look to subjective intent all the time in determining the illegality of a search. In Florida versus Wells, we talk about the fact that how do you decide whether it's an inventory or a search? You look to the purpose. Were they using inventory as a ruse to search the guy's belongings? That's looking at the guy's subjective intent, his objective mind. This determination of the distinction between safety inspections and general criminal safety inspections may not require a Fourth Amendment protection, whereas general criminal investigations do. How do you decide between the two? You look to the intent of the officer. Some of y'all from Indianapolis understand. It's a clean city, nice, trim, all the buildings are washed, Same architect that did your train station, the one in Paris is now an art museum. Very cool. I mean, everybody, and they don't like their drugs. And so what they decided they do, they put a traffic safety stop on every fucking street surrounding the town. And they brought in drug dogs. And that was cool. But what the Supreme Court says, the purpose of that was not to maintain safe roads. It wasn't to check driver's licenses and ensure that the vehicles were safe. You were doing a criminal investigation. That's why you had the drug dogs. And you cannot sanction stops justified only by the generalized or ever-present possibility that interrogation and inspection may reveal that any given motorist has committed some crime. Great case, Bond versus U.S. from 2000. This is a little case from a little public defender in San Antonio, Texas. That public defender's office won 3 Supreme Court cases in barely 7 years. That's better than most law firms I know. And in this case, it was Chief Justice Rehnquist, I would say, wrote the opinion, and this is one of those where the border patrolman goes along and feels on the buses and feels the bags, and he felt something, he felt like a brick, and he asked the guy, is that yours? Yeah. Can I search it? Yeah. And they said, no, you squeeze that. And that concept, remember, going back to Scalia, lifting it 3 inches, manipulating between the index and finger, squeezing the bag. And Scalia, this time is on the other side. He said, well, hang on. The stewardess, they're always moving all your shit. They're touching it. They're moving it. People said, fuck, I don't know, this bag's going the wrong way. This way, and I put mine in here. My jacket's down there. What about my computer? This way people are touching all kind of shit, okay? But what the Chief Justice says is, yeah, but they were touching it in an exploratory fashion. How do you know? How do you know it's in exploratory fashion without looking objectively to determine what's in their mind? Their subjective intent is how you decide. U.S. versus Pope is a great case out of the Fifth Circuit from 2 years ago. And this is a case, this is one of our cases. But anyway, this police officer comes and he's, what happened was he made an undercover purchase of some illegal prescription drugs. And he doesn't act on it. And then about 78 days later, he gets some just raw information that the guy's got a speed lab at the place. So he knows that that's insufficient. So he goes to the magistrate and gets a warrant based upon the previous purchase of the prescription drugs, which the Fifth Circuit said, that's stale, and besides, not mentioning the amphetamine under Franks versus Delaware, that was dishonest. The failure to advise the magistrate, the omission, was a dishonest, intentional misrepresentation, and this is the Judge Wiener. We know from Baird's own lips that he lied to the magistrate. Well, if you look at the Judge Jolly from Mississippi, who dissents, he says, wait a minute, the good faith exception ought to apply. Why? Because you don't look to his subjective intent. Well, he might have been a bad actor, but you look objectively, and objectively he had a right to get that. And I love Judge Wiener's response. The defendant accuses this writer of advancing a subjective determination on the basis of what we perceive to be Officer Baird's state of mind. But we obviously are not conducting a subjective inquiry. Quite to the contrary. We are objectively determined that Mr. Baird's a lying sack of shit. You know, and that's where I think you need to get to. Fact-bound inquiries. The way you win these cases is not necessarily with the law, but with fact-bound inquiries where they simply shame them into doing it. Shame them into doing it. Meeks versus State. This is another case Edmond and I had back in '85. And this local sheriff in Sanderson County, Sanderson, Texas, way out, you know, it's way out in West Texas. I mean, it's got one of those old courthouses with triple hung windows, you know, and no air conditioning when the windows are up and the curtains are kind of, I mean, the blinds are kind of going like this. And it looks like American Gothic. The guy could have a pitchfork in his hand. Blue eyes, you can look right through his fucking eyes and see the clouds on the other, you know, out there. Wake up, you know, hey, we're over here. You know, evidence, testimony, you know, really weird. Anyway, so the sheriff stops everything that moves, all right? What did we do? We spent 3 weeks. We proved that the Highway Patrol, narcotics officers from Laredo, license and weight officers, deputy sheriffs from Terrell and Brewster counties, by the way, that's 700 miles away, auto theft officers from Del Rio, wildlife officers from Pecos, Border Patrol officers had green buses pulled up, you know, picking up all the undocumented people. And what the Court of Criminal Appeals in Texas finally said in '85 was, look, that's a fishing expedition. Why? They looked at the subjective intent. That was an exploratory general criminal investigation. Nothing to do with safety of the roads or the drivers. If any of y'all see Tommy Meeks, please let him know. It took him 7 years to render this opinion, and he discharged his prison sentence. He never found out that his case was reversed. U.S. versus Green, another instance of fact-bound inquiry. Officers, this is New York versus Belton, Brown Line Rule. They've got the guy on the pavement 6 to 8 feet away, 6 to 10 feet away from the vehicle. He's hog-tied, hands handcuffed behind his back, feet brought up and tied to his hands. Fact-bound inquiry. They proved that up. And what the court said, look, under Trammell and New York versus Belton, that's simply a stretch to argue this guy is going to get to evidence and destroy it or grab a weapon and harm an officer. Fact-bound inquiries, again.